Welcome to Family Law Unfiltered with Emily.
Welcome to Family Law Unfiltered, the podcast dedicated to demystifying the complexities of California family law. I'm your host, Emily C. Marks, and today we're tackling real-world issues regarding child custody and divorce. In future episodes, we'll be talking about child support, property division, and domestic violence. Watch this podcast if you're interested in protecting your reputation, your parental rights, and your future. Let's dive in. People often wonder, how much does a divorce cost in California, in Orange County? It is only $435 to file for divorce in Orange County or in any of the counties in California. That is the current filing fee. But beyond that, the costs vary wildly. The costs beyond the initial filing fees and possible process serving fees are driven by attorney fees, which depend heavily on the complexity of your case and how much you and your ex can agree on. A simple, uncontested divorce where you both agree on everything costs about $5,000. That's what my office charges. And that takes you from pleading through financial disclosures all the way to judgment. However, if you disagree on any of the issues that are present in your case in a divorce, that could be property division, including division of debts, that could be child support, spousal support, could be date of separation, could be business valuation, any of it, that is going to increase your fees exponentially. Every time you go to court, you have to pay your attorney to go to court to prepare and possibly to draft pleadings in advance of those hearings. If you go all the way to trial, you'll likely need to hire experts, forensic accountants, etc., child custody evaluators, and multiple court hearings all add to the expense. Not to mention, when you get to court, yours is not the only matter on calendar that day, so you will wait about half the day to be heard. And most attorneys, including me, we charge for this wait time. People often ask, at least on Google, what is the difference between a private judge? What can a private judge do? When you file for divorce in Orange County, you will be assigned a judge at random. Your case will go through the public court system, and you will be subject to their court calendar. And therefore, hearings not only might be, but are scheduled months apart unless they're emergency hearings, rarely granted. And judges have limited time for each case on each day. Alternatively, you and your spouse or ex can agree to use a private judge. And this is governed by the California Rules of Court. It is allowable. It allows you to have a retired judge or experienced attorney act as your judicial officer. The orders and the judgment are just as binding as a publicly assigned judge. The benefits, however, are substantial. The benefits include speed, flexibility, and that means that your private judge will accommodate your calendar instead of the other way around. Privacy and expertise. You may hire a private judge or experienced attorney who has a specific expertise in your contested area. Next, let's talk about custody, visitation, and support. Let's talk about some core principles and common myths. This is the heart of many family law cases and the subject of much litigation in Orange County. There are many misconceptions. The paramount standard for all child custody decisions is not 50-50. That is not a presumption in California. It is the best interest of the child, and that is outlined in Family Codes 3040 and 3011. The court considers numerous factors when determining what is in a child's best interest, including the child's health, safety, and welfare, history of abuse by either parent, generally speaking, and can invoke a rebuttable presumption, Family Code Section 3044, if that abuse occurred in the previous 5 years, where the abuser it is determined to be detrimental to the minor child to award custody, even joint, to an abusive parent. The court will consider the child's emotional ties with each parent, maintaining contact with siblings, the same timeshare or the same parenting plan is presumptively in the child's best interest to share that parenting plan with a sibling. And we'll also consider the child's emotional ties with other people in their life. The court will consider a parent's ability to provide for the child's needs, and that includes food, clothing, shelter, medical care, but it also includes availability and emotional support. Another factor that the court will consider is a parent's ability and willingness to encourage frequent and continuing contact with the other parent who does not have custody. And that's required by Cal Family Code Section 3020. And you'll often hear judges mention that factor in court settings. If the child is 14 years or older, the child has a presumptive right to be heard. If the court does not entertain that child's wish to be heard, then the court will have to give or has to give reasons why not, why the court is declining to hear from the child directly on the record. For children under 14, the court does not have to put in the record any reason why the court is refusing the child's wish to be heard, but the court will consider arguments in favor of hearing from the child directly regarding parenting plans. If the court does not want to hear from the child directly, like by having the child examined and cross-examined in open court or even in a closed court, but in a litigation setting, the court may interview the child in chambers. The court may appoint minors counsel. The court may order the parents and the child to participate in a child custody investigation through family court services. This is one of the best programs that Orange County offers. These investigations are thorough, comprehensive, detailed, and very helpful in terms of the court's analysis in determining what parenting plan is in the best interest of the child. The investigators will even contact collaterals like teachers, therapists. They will run background checks, and they will uncover any mistruths that have been included in the pleadings that are being challenged by the other parent. So they're very helpful for the truth-telling parent. Orange County is not a recommending county, except for the child custody investigations that I just described. Parties are ordered pursuant to legislative rules and regulations. All parents in California have to attend mediation with the other parent. Orange County does not report any recommendation or anything that was said during the mediation to the court at the time of the hearing in the event the parents don't come to an agreement during mediation. Other counties do. Other counties are considered recommending counties. And these are helpful, I guess, but not as helpful as the child custody investigation, which is why I really like practicing in Orange County in contested custody litigation, because we have that resource. Let's talk about the difference between legal custody and physical custody. Legal custody is the right to make decisions regarding health, education, safety, welfare of and concerning the minor child. The standard is that parents will share joint legal custody, and that means they have a duty and an obligation to discuss major decisions regarding a list of what the court considers important legal custody decisions, and those are provided to you on a form and typically in the court order that awards legal custody. And it's pretty hard to take legal custody or rights away from a parent. You typically have to show that the parent is either absent or has made bad decisions in the past or has defied legal custody orders in the past. So there's two types of legal custody orders, and they include sole and joint. Sole legal custody, one parent gets the right to make the decisions related to the child's health, safety, and welfare, doesn't have to hear from the other parent. Joint legal custody, parents have to confer, and if they cannot agree, one parent has to file a motion or a request for order requesting that the court order the specific legal custody requests that the other parent will not agree to. Sometimes the courts will give one parent decision-making power so that they don't have to keep going back to court, but they will order or place upon the parent who has that decision-making power a duty to notify, a duty to notice the other parent so that the other parent can file a request for order to stop the action if he or she so desires. Like legal custody, there is no orders that the court can make other than sole physical custody or sole or joint physical custody. The court cannot order primary physical custody. It doesn't exist in family law. Parties can call it whatever they want, but it wouldn't be included in a judgment. It has to be sole or joint. Sole physical custody means means child or children reside primarily with one parent and visit with the other parent. Joint physical custody means the child spends frequent and continuing contact with both parents. It doesn't have to be pursuant to a 50-50 schedule, but it can. You can have joint physical custody without having a 50-50 schedule. Some of the even schedules, common parenting plans that are 50-50 are the week on, week off, which is suitable for teenagers or children over 10, I would say. There's also the option to have a 2-2-3 schedule or a 2-2-5 schedule. The 2-2-3 schedule means that parent A has the child for 2 days, parent B has the child for 2 days, and then they rotate weekends. The 2-2-5 schedule means that one parent has the children or child on Monday and Tuesday, the other parent has the children or child on Wednesday and Thursday, and then they rotate weekends. As an attorney, I often advise my clients to the 2-2-5 because it is more predictable. You can calendar it easier. But some people decide that it works better for them to have a 2-2-3 schedule. Where one parent has sole physical custody and one parent has visitation, the visitation is going to look like this. They're going to likely have alternating weekends, and you can expand those weekends. They can be Friday to Sunday. They can be Saturday to Sunday. They can be Thursday to Monday. Whatever you can agree on or argue to a court, that would be the alternating weekends. It's not a set number of days. It can take on many variations. And then a midweek visit. That can be a dinner visit or an overnight visit if the parents are close enough. And if the visiting parent can get the children to school on time, then the overnight would likely be ordered. I mentioned that parents have to go to mediation in any custody and visitation matter. Every time a parent files a request for order in California or ends up in trial in California, the court orders them to mediation before any hearing. And then we also talked about the child custody investigation, which are just so wonderfully thorough in Orange County. I often and cost effective because of all of the evidence that they gather. You spend about $1,500 or $1,600 on the child custody investigation because the costs are split, and you get about $20,000 worth of evidence. So I often encourage my clients to seek those orders for child custody investigations. The court can also order minors counsel or appoint minors counsel to represent the child. Not my favorite option. I typically veer away from that. I find them to be overworked. Nice enough people, but they're so often in court. I don't know that they have the time to prepare outside of it. I do my best to assist minors counsel on my cases where minors counsel is appointed by feeding them information. But you can't control the other person. I do prefer the child custody investigation over the appointment of minors counsel. But sometimes courts will order minors counsel over my objection, and there's nothing I can do but try to educate them on the case. I know they have so many documents to look at, so many clients, so many people to meet with, and they have to be in court. We talked about the direct testimony from the minors. And again, this can be a very effective tool. If you have a 14-year-old who has a preference, the court is going to hear from him or her and often resolve those credibility disputes that arise in custody and visitation litigation generally. And the hearsay, a 13-year-old or any child may make a hearsay statement, and parents might try to get it into evidence, and the court will not allow the hearsay statement into evidence because it's hearsay. which is an out-of-court statement, not taken under testimony and being used or repeated or reiterated and attributed to that speaker in court. When the child testifies directly to a judge, it's no longer hearsay. So once the child is 14 years old, all of those he said, she said allegations that have been flying through the court between parties in a case for years and years, they suddenly end, because no longer does one parent have to allege what the child says, and then the other parent have to oppose or defend against what the child supposedly said. The court can hear directly from the child. So it's very helpful. But the goal of all of these processes is to gather comprehensive information to help the court make a decision that is in the child's best interest, because there's custody and visitation litigation. Sometimes it comes down to credibility, and you don't want to spend tens or $20 or $30 or $40,000 on a hearing that's going to come down to credibility. It's really hard to foresee what's going to happen there. In the next episode, we will be talking about child support and other support matters, and some alternatives to people seeking custody. Some alternatives from going through the family court if parties want custody of a minor child or have to seek custody of a minor child. So I hope you found this informative. And if you have any questions, please leave them in the comments. I will do my best to answer them in the next episode. I thank you for watching, and I look forward to seeing you soon.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.